I cannot tell you how much of a privilege and pleasure it is to introduce our next speaker. I know you know him, and you will not believe what he has done to his schedule and his staff to be here, and we are eternally grateful. He's a dear friend not only to education, but he has personally interceded on a number of events for the Wecht Institute, not only speaking here twice, this is his second appearance with us, but on some very serious grants that we've submitted, and he successfully prevailed on our behalf. It is my pleasure to introduce the senior United States Senator from the Commonwealth of Pennsylvania, Senator Arlen Specter.
Thank you. Thank you. Thank you. Thank you. Good morning, ladies and gentlemen. I am pleased to join in this distinguished symposium. I compliment Duquesne University. I compliment Dr. Cyril Wecht for bringing together a very distinguished audience. I understand from most of the states in the United States and many foreign countries to focus on the assassination of President Kennedy and, in effect, pay tribute to a great American president cut down in the flower of his youth with great accomplishments but even greater potential, and to take another look at the events of November 22nd, 1963, which resulted in the great American tragedy. On November 29th, 7 days later, President Lyndon Johnson issued a famous executive order establishing the commission to investigate the assassination of President Kennedy, and selected the Chief Justice of the United States to head the commission. When Chief Justice Warren called in the lawyers who were asked to take on the investigative responsibilities, he told us about how he had come to undertake the assignment. He said that Archibald Cox, the Solicitor General, had come to him. He knew Cox well because he argued cases before the Supreme Court, and Archibald Cox asked him to head the commission, and the Chief Justice said no, he couldn't do that. Case might come before the Supreme Court, and he had very heavy responsibilities. And then the Deputy Attorney General, Nicholas Katzenbach, came to see him, made the same request, got the same answer. Bobby Kennedy was Attorney General and was still broken up about the events on the murder of his brother and did not talk to the Chief Justice. But then President Johnson summoned Chief Justice Warren to the Oval Office and importuned him to take the assignment. As the Chief Justice told us, the President said there is unrest around the world. There are questions as to whether the Soviets might have been involved, whether the Cubans might have been involved, and it was a matter that the President urged the Chief Justice to undertake. And the Chief Justice told us, I said to the President, I can't do it because the case might come before the court and I have very heavy duties. And then, according to Chief Justice Warren, President Johnson said, if the Commander-in-Chief asked you to put on the uniform of your country in time of national emergency, would you decline? And Warren said at that point I couldn't say no, so I said yes, and he undertook the assignment. The other members of the commission, as you know, were from the Senate, House of Representatives, former director of the CIA, John McCloy, and a very distinguished panel. They then set out to recruit attorneys to conduct the investigation. They decided that they would move outside of Washington, D.C., move outside of the federal bureaucracy in order to avoid having anyone say, well, it's a same old group, insiders. And they selected lawyers from Philadelphia. Bill Coleman and I were asked to join. from Cleveland, from Chicago, from Los Angeles, from Denver, from New York, and around the country. I had tried a big case as an assistant DA at the time, the prosecution of the local 107 Teamsters, which came out of the investigation of the McClellan Committee in the mid-50s, where Bobby Kennedy was the general counsel. And as a matter of fact, Senator John F. Kennedy was on the panel. And after getting those convictions and sending those crooks to jail, the Attorney General Kennedy invited me to Washington and asked me to join the Hoffa prosecution team, and I declined. I had 2 young sons, and I had to finish up what I thought was very important work on the case, and decided to stay in Philadelphia. And a few months later, the president was assassinated, and I was asked to join the commission staff. And with some reluctance, I decided to do it because of the importance of the job. The investigation proceeded on the record. I was asked to handle what was called Phase 1 of the investigation, which involved the activities of the president, which brought up the medical testimony, what had happened to the governor and the president, the bullet wounds on their bodies. And Francis W.H. Adams was senior counsel. At the outset, we were divided into senior counsel and junior counsel. Frank Adams had been the police commissioner of New York City and was a prominent Wall Street lawyer, and had been called to Chief Justice Warren's attention at the funeral, I'm told, of Senator Lehman, when Mayor Wagner said, "You ought to get Frank Adams. He's had experience protecting the president, tall buildings, et cetera, et cetera." And Frank Adams joined the staff. But in the course of the inquiry, his law practice was too heavy. He had expected to spend about 6 weeks on it, and as you know, the investigation lasted until September when we published the report. So the responsibility to handle the matters came to me, and we then set out to question witnesses. Our charge by the Chief Justice and the Commission was not to make any assumptions as to who was the assassin or whether there was a conspiracy or what the facts were, but investigate. And I'd had some experience at that, and off we went. One of the most prominent interviews that I conducted with Joe Ball, who was senior counsel in Area 2, one Friday afternoon was at Bethesda Hospital when we were going to have the autopsy surgeons in on the following Monday. And we were having quite a debate within the commission as to whether we ought to interview witnesses in advance or whether we should not interview witnesses in advance. And Norman Redlick, who was the key aide to Lee Rankin, who was the general counsel, had a strong view that we ought not to interview witnesses in advance. And Joe Ball, who had been president of the California Bar Association, man in his early 60s, a very distinguished trial lawyer, said, of course we should interview witnesses. And I had been a trial lawyer, not like Joe Ball, but I tried cases. And I said, of course we should interview witnesses. How are you going to ask witnesses questions on the record if you hadn't interviewed them? And we decided finally at the last minute to interview witnesses. And we went out to Bethesda, Joe Ball and I did, on a late Friday afternoon to meet Dr. Humes and Dr. Boswell. I think Dr. Fink was there. Dr. Fink was from Walter Reed. And the commanding admiral brought in Dr. Humes, Dr. Boswell. And Dr. Humes was very reluctant to talk to us. He wanted to see some identification. Well, we didn't have any identification except our building passes for the VFW building. And it was one of those cards where Arlen Specter was typed crooked. And it was a different type from the rest of the card. obviously not exactly a very good credential. But after a while, with the commanding admiral telling Dr. Humes to talk, he decided to tell us some things that were going on. And he started to describe what had happened on the autopsy examination. And I had seen the autopsy report, so I knew at least that much. And he said that the bullet had passed between two large strap muscles, and it hit nothing solid as it went through the pleural cavity and sliced the president's trachea. And when they conducted the autopsy, they did not know what had happened in the front until Dr. Humes called Dr. Perry, Malcolm Perry, who had attended President Kennedy at Parkland. But at any rate, the bullet, according to Dr. Humes, passed between two large strap muscles, as I say, hit nothing solid, exited, had nicked the president's tie, and the tie had been cut off with the knot intact when they attended to the president at Parkland. And when I heard about that, I immediately speculated about the path of the bullet beyond. Governor Connally was seated immediately in front of the president in the jump seat, and as the evidence unfolded, had a bullet wound slightly to the left of his right armpit, grazed his rib. His wrist had been shattered, and the bullet then lodged in his thigh. And we conducted an extensive series of tests, and that was the essential beginning of what I had at first said was the single bullet theory, and after a few decades decided it was the single bullet conclusion. And when ABC did their 2-hour special on Thursday on a re-examination, they came to the conclusion that it was a single bullet fact. Now, I understand in walking over that there may be some dissent in this audience. And I'm prepared for dissent. This investigation, ladies and gentlemen, was conducted on the record without a view to presenting the case in any sort of an attempted persuasive manner. That was not our objective. When I investigated cases as a district attorney, I would get all the evidence in and put it all together and work through any inconsistencies and analysis to see what had happened. But that's not the way this investigation ran. So that when I took a look at the medical reports of Governor Connally's wrist and saw that there were metallic fragments at various levels of the wrist, I said to myself, how can the bullet have done it? Because the whole bullet found on what was believed to be Connally's stretcher was intact. So I questioned Dr. Gregory in Dallas. I went down and took a series of depositions, but then we focused on it when Dr. Gregory testified before the commission, and I asked him the questions, and he brought in the x-rays, and the x-rays showed that there were metallic fragments at various levels of the wrist, but they were of postage stamp weight, and Dr. Gregory said that they were consistent with having come from the bullet believed to have been found on Governor Connally's stretcher. There's been a lot of talk about zigzags and the bullet going down and the bullet coming up and all the rest of it, emanating significantly from the fact that the hole on the president's shirt was low down, several inches below the collar line. But of course the issue is not where the hole was on the president's shirt, but where the hole was on the president's body. And the hole on the president's body was at the base of the neck. President Kennedy wore a back brace, He stood up and down in the car as he moved through the streets of Dallas. He was waving, as the photos show, and the shirt naturally rode up. We did an exhaustive series of tests. We recreated the substance of the president's neck by goat meat in a gelatinous solution. We fired the Mannlicher Carsano at the approximate distance, 275 feet, to see what the muzzle velocity was, about 2,200 feet per second, and about 2,000 when it got to the object, and about 1,900 coming out. And we did tests on cadaver wrists, and if a cadaver wrist was hit with a pristine bullet, it shattered the wrist and flattened the bullet. So we knew that Governor Connolly's wrist was not hit with a pristine bullet. And we did some tests on anesthetized goats, and one of the tests had a flattening of the bullet when it's grazed the goat's rib, similarly to what had happened to Governor Connolly. That's all a very brief condensation. The full text is set out in the Warren report. And since I have been asked about this matter continually since the event, I speak at a lot of high schools, and I speak at a lot of colleges, and I speak at a lot of town meetings. As a matter of fact, I speak a lot. And there's a tremendous interest in the subject, evidenced by this enormous group today. So I decided to write it all down so that the guy who would come up with the judgment would have laid it all out and put it in a book. We then did what we called on-site tests in Dallas. There was a lot of interest in concluding the investigation very, very promptly, and we were well aware of that, but the staff was determined to do a thorough job. And I was given the job of questioning the witnesses who were in the presidential motorcade, and the Chief Justice was present on all of these occasions. Other commission members came in and out. Senator Richard Russell was engaged in the filibuster of the Civil Rights Act in 1964 and came to only one meeting, the questioning of Governor Connolly. And Chief Justice Warren would sit as I would ask the questions, and when James Greer testified, the driver of the limousine, I said, Mr. Greer, to the best of your ability to recollect, this is not verbatim, it's in the transcript though, what was the speed of the car at the time of the first shot? As best you recollect, what was the speed of the car at the second shot? As best you recollect, the third shot? What was the distance traveled between the first shot and the second shot? The Chief Justice would sit there, and he was strumming his fingers. And after a while, he interrupted the proceeding and took me into a side room, said, "You've got to speed this up." And I said, "No, Mr. Chief Justice, I'm not going to speed it up. We've got to ask all these questions." I had been chief of the appeals division in the Philadelphia DA's office, and I knew what a record looked like when it was typed up. And I said very respectfully to the Chief Justice that this was the way I thought the questioning ought to go. And he said, "Okay, let's get on with it." He was not a very patient man. He's a brilliant man and a marvelous jurist, but a great administrator, and he wanted to get it all going. But we tried to do, I think we did, a professional job on the investigation. When it came to the on-site tests, by this time the younger lawyers had pretty much taken over. Joe Ball was the only senior who was there all the time. Bill Coleman was there much of the time. And we had a major disagreement with the commission as to whether we ought to do the on-site tests. And the younger lawyers insisted on it. We went down to Dallas, I believe it was in May, it's on the record, and blocked off the streets at 5:30 so as not to interfere with vehicular traffic, and caught the vehicles and people to simulate the president and the governor about the same height, and got the Mannlicher Corsano and had it mounted about where the sniper's nest was, and recreated the scene. At a later point in the proceedings, there was a big discussion whether we were going to print the record. And the Chief Justice thought we should not print the record as a matter of cost. And the younger members of the staff went to the members of the House and Senate. And they had no problem with printing the record because they print records all the time. Virtually everything is in the congressional record. Nobody pays much attention to what is said on the House or the floor with respect to accuracy, so it was a commonplace, and they were used to it. And we printed the 26 volumes and the 17,000 pages. And most of the criticisms which have come from the analysts have come from all of the record which we put out there. And in 1992, Senator Boren and I authored legislation that originated in the United States Senate to make all the records available unless there were national security reasons. But it was a very broad mandate, as broad as we could make for it legislatively. But I think the younger lawyers had quite an impact, I know we did, on getting the record out and pursuing all facets of the inquiry. I made no bones about my thinking that we should have seen the x-rays in the photographs, and we did not. And I have commented about that publicly, wrote a hot memorandum to J. Lee Rankin on the subject on April 30th of 1964, saying that although the x-rays and photos would be corroborative only from what the autopsy surgeons had testified to, I thought we should see them. We should see all the evidence, and we were not permitted to see them. And that was a bad judgment. Later, the x-rays and photos were examined by forensic pathologists, and as I recollect it, and Dr. Weck can confirm this, he was one of the forensic pathologists. He called them forensic scientists, and we were on the radio yesterday. Said I wasn't a forensic scientist. Can you imagine that? Said I was a pretty good senator, though. My recollection was, Dr. Weck, that it was 7-1. 7 of the forensic pathologists agreed with the single bullet fact, now that we know what it is, and Dr. Weck did not. But at any rate, I thought they should have been seen, and made as strong a case as I could. And there was never any official reason given, but we speculated that there was a concern about having these photos in the public domain. Almost everything gets into the public domain that isn't under lock and key and double barred, et cetera, et cetera. And when I wrote my book, I asked permission to see the photos, and I got to see them because I was a senator. I wouldn't have gotten to see them if I hadn't been a senator. But I did take a look at them. Burke Marshall was in charge of them, a man who was close to the Kennedys and an assistant attorney general. And why Mr. Marshall was in charge of them, I could never figure out, but he was in charge of them. But I did get to see them, and they corroborated what we had found out. The only thing the commission had to work on were some rough drawings. When Joe Ball and I talked to the autopsy surgeons that afternoon in Bethesda, we were asked if we'd like to have some artist drawings. And I said, well, Joe and I said, yeah, fine, let's have them. Better than nothing. We were wrong about that because they were inexact, and they've been the subject of a lot of controversy. We put them into the record, but they were artist renderings without having the photos or other more detailed information available as to what they would copy from. The report was that the Chief Justice had seen the photos. That was not in the report, and that was not official, and even if he'd seen them, it wasn't sufficient. The staff should have seen them, the other commissioners should have seen them. And Elmer Moore, who was the chief's bodyguard, showed me a photo which he said was the back of the president, and I told him I didn't want to look at a non-authenticated photo. I wanted to see the real McCoy. But at any rate, that was one of the points of controversy. When Jack Ruby's testimony was taken on June 8th of 1964, I was initially excluded from the event because the Chief Justice wanted to limit the number of people who were in the sheriff's kitchen, which is where it was taken in the Dallas jail. And I was asked to go to Dallas on that Sunday so that I could explain to the Chief Justice the single bullet theory. It was only a theory at that point. And I took the chief to the corner of the 6th floor Texas School Book Depository building where the nest had been found, sniper's nest, and I had about, I estimate, I didn't time it, about 8 minutes to talk to Chief Justice Warren, to tell him about the trajectory and the bullet wounds, etc., the round regular hole on the back of the president's neck and the round regular hole on the subsequent shot which hit the president was fatal, and the wound on the back of the governor's slightly to the left of his right armpit with a little yaw on it, and the trajectory, etc. And it was the longest time I heard Chief Justice Warren speechless. And when I finished the explanation, he turned on his heel, didn't say a word. I didn't know whether he liked it, disliked it, or what he thought about it. But later the commission agreed with it. When Ruby's testimony was taken, I was asked to join it about halfway through. In retrospect, obviously, it was quite a proceeding to have Jack Ruby's testimony taken. And just as a matter of local color, San Francisco and Philadelphia were tied for first place in the National League at that time. Chief Justice and I had had some discussions on a partisan way going out on the plane, and I was watching the game and didn't mind too much being excluded, but I was asked to come down because Jack Ruby, I was told by Elmer Moore that Jack Ruby wanted someone in the room who was Jewish, and I was the only one who qualified, so I was brought into the deposition about halfway through. And Jack Ruby was conclusively in charge. As the transcript later showed, when the deposition started, instead of calling the commission to order, the opening lines are, and I have not reviewed all of this because there's just too much to re-review, so I'm giving you best recollection. It started off, Ruby said, "How do you know I'm telling the truth? I want a lie detector test." And Chief Justice Warren, brilliant as he was, wasn't very fast on his feet. And he said, "Well, Mr. Ruby, if you want a lie detector test, of course we'll give you a lie detector test." And later that night when we were flying back to Washington, Chief was really a remarkable man. He was not a spring chicken. He picked me up at the International Inn that day at about 7, so he was up and at it in advance. And when Lee Rankin planned the trip for the Chief Justice, he planned a week's trip. And the Chief looked at it and said, "I can't spend that much time, Lee." This is what was told to me. So Rankin gave him the weekend, leaving Friday at noon after the Supreme Court business was over and coming back Monday morning. Warren allegedly looked at that, or reportedly looked at that and said, "Give you one day," and he gave him Sunday. And we flew down, flew back about midnight, and we were flying back. Warren was going through reports, and he was a dynamo administratively. And he said, "What are we going to do about this lie detector test?" And I said, "Well, Chief Justice, you told him he'd have one. You got to give him one. Or people will think there's a cover-up if you don't do it." He said, "Well, who are we going to get to do it?" And I said, "Well, I think you ought to have some polygraph examiner outside the government. I don't think we ought to have somebody in the government because it'll be suspect, like the ballistics from the Illinois State Police, as I recollect it." And he said, "You know how much money they'll make?" And I said, no, I don't know, Mr. He was very upset about people making money. It was just outraged that Zapruder got $150,000 for the film. The chief had been public service all his life and was very, very parsimonious. But I said to the Chief Justice, if Jack Ruby decides he doesn't want a polygraph, only he can decide that. There were a series of Supreme Court decisions at about that time that said only the individual could make a waiver, the intelligent waiver doctrine. The chief had decided those cases but wasn't familiar with them. But I reminded them as to what they said. And he said, well, I want you to go down there and I want you to say to him that he doesn't ask him, see if he won't give up the polygraph test. And I said, okay, Mr. Chief Justice, I will do what you said. Jack Ruby's brother had a lawyer named Saul Dan in Detroit, as I recollected, who didn't want Jack Ruby to take the lie detector test, but it was up to Jack Ruby. But at any rate, as it worked out, my recommendation for an independent lie detector examiner was not followed, but the FBI chief polygraph operator, a man named Bell Herndon, was, and we went down to Dallas one Saturday morning, and the transcript is in the record, and I said something to the effect, Mr. Ruby, if you want a lie detector test, you'll have one, but if you don't want one, you don't have to take one. It's a decision that you can make. And Jack Ruby had come to the event with a series of questions. He had all his own questions that he wanted to ask. And as you may know, a lie detector test is supposed to last about just a few minutes with a few test questions and a few substantive questions. That lie detector examination lasted until midnight, from noon until midnight. Everybody had questions that they wanted to ask. And you could draw your own conclusions as to the validity of it. When we were flying back to BWI the next day, Bell Herndon said to me that he thought Ruby was telling the truth when he said that he had no connection with Oswald and was not part of any conspiracy. We were later told that J. Edgar Hoover had reviewed the polygraph examination and thought that it was not reliable, that Ruby did not have sufficient mental competency to conclude that the lie detector test was valid. We printed the transcript of the examination and printed the graft so that people could take a look at it and decide for themselves what they thought about the examination. There were factors which led me to question whether Ruby was totally in touch with reality. During the course of the examination, he called the Chief Justice and me. The stenographer ran out of paper. And when I had come in, this is probably more than you want to hear, just some of the sidelights, Ruby looked over at me and mouthed the words, "Are you a Yid?" And I sat there, not saying anything, and then he went to the end. This is all in my book, 1475 in paperback. I'm not telling you anything I haven't said before. And I just sat there because I knew what the transcript was going to look like. I wasn't going to say anything to him. And fortuitously at that moment, the court reporter ran out of paper. And Ruby called the Chief Justice and me over into a corner. Like I say, he was in charge. And he said, "Chief, you got to get me to Washington." And about this time, Joe Ball came over. He figured if Arlen Specter at 34 could be there, so could Joe Ball at 62 or 3. He was a senior guy. And Ruby said to him, "You Jewish?" Joe Ball said, "No, get out of here." And Ball did as he was told. And Ruby then said to the chief, "You got to get me to Washington. You got to get me to Washington." He said, they're cutting off the arms and legs of Jewish children in El Paso and Albuquerque. So you could see some question as to whether he was in touch with reality, at least at that time, and perhaps people go in and out, whatever. But at any rate, the chief said he couldn't, I can't do that, Mr. Ruby. Ruby said, get a hold of Fortas. I barely knew who Fortas was, but Ruby did. And at any rate, Ruby never got to Washington, and then we went back and finished the deposition. And at one stage, Joe Tonnehill, who was Jack Ruby's lawyer, was sitting next to Gerald Ford, then a congressman, a commissioner. And Tonnehill handed Ford a note. And Ruby saw Tonnehill hand Ford the note and said, I want that. And just as he was told, Congressman Ford got up and handed Ruby the note. And Ruby opened up the note and started to read it, and he couldn't see it. His eyes were bad. So the Chief Justice of the United States took off his glasses and handed his glasses to this fellow who was under the conviction of murder in the first degree with the death penalty. And Ruby read the note, and the note said, you see, I told you he was crazy. And Ruby threw the note down. If you had a sense for history, it would have been a good note to pick up. But I didn't. I don't know what happened to the note. But we went on with the deposition, and the commission concluded, as you know, that Ruby did not have anything to do with the assassination. The events at the Dallas police station were bizarre, to say the least. Ruby ran a strip joint, as you know, and had access to the police station all the time, and came in to give the officers coffee and sandwiches, and had great rapport with the police department. And it appeared that it was just another day when Jack Ruby was at the police station as hanging around. And you know his explanation that he wanted to be a hero and wanted to save Mrs. Kennedy the trauma of coming back to Dallas for a trial. The commission adopted the single bullet theory, now the single bullet fact, and concluded that Oswald was the sole assassin, and the evidence was overwhelming from the point of view of a criminal case or a prosecution. There was a palm print on the Mannlicher Carsano rifle. It was traced to Oswald's buying it from a Chicago mail-order house under the name of A.H. Heddle. He carried a suspicious-looking package into the Texas School Book Depository building that day, saying that it contained curtain rods, when it later was shown that he had curtains in his room and curtain rods. The whole bullet found on what was believed to have been the Conley stretcher ballistically came from the Mannlicher Carsano. The large fragments found in the front seat of the presidential limousine conclusively came from the Mannlicher Carsano. There was a print on one of the boxes containing rolling readers in the sniper's nest. Of course, Ruby then fled the scene and went to the Texas Theater, and flight an indicator of guilt, and shot and killed Officer Tippett. So I think the case was conclusive. Enormous speculation arose because of the background of Lee Harvey Oswald. Renounced his citizenship, as you know, went to the Soviet Union, married a Russian woman, was on the Fair Play for Cuba Committee, made a trip to Mexico City. A lot of suspicious circumstances, and the commission, as you know, concluded that there was no evidence of a conspiracy. If you want to prove that Arlen Specter was at Duquesne on November 22nd, it's not too hard. Find a witness or two. If you want to prove that Arlen Specter was not at Duquesne on November 22nd, you have to have somebody having every aspect of the locale under observation, so nobody can conclusively prove a negative. I think had there been a conspiracy, we would have come to light a long time ago. My experience is that nothing stays secret in our society, and somebody would have told about it a long time ago. The commission undertook to track down all of the leads which it could. After the commission concluded its work, a graduate student at Cornell, Epstein, wrote a book. I had not commented about the origin or development of the single bullet theory. Epstein identified, after talking to the staff members, that it was my work, and when it was so identified, I acknowledged that. I had some concerns initially about talking about the matter because of the concern about attorney-client privilege, but I had been elected DA of Philadelphia in 1965, and as a public official, I thought I should talk about it. There was enormous interest. When I approached here, I saw the speaker on the podium was Mr. Lane. Mr. Lane had a film, Rush to Judgment, following his book. BBC wanted to debate. David Bellin and I went to London in late January of 1967 and debated Mr. Lane for 4 hours and 45 minutes on live television. Josiah Thompson wrote a book, 6 Seconds in Dallas, and I debated Mr. Thompson at the University of Pennsylvania Law School. Dr. Wecht and I have had conversations from time to time. Cyril and I were together about a year ago here at Duquesne. I was asked to speak, and Dr. Wecht was there, and we chatted about it. We had an independent group which went over all the evidence. We did not have available to us a lot of sophisticated devices later applied, like triangulation. I looked at the Zapruder film under a microscope for long periods of time. I questioned Governor Conley when he came in on April 22nd. He had to recuperate from his wounds for a long time. We were disappointed that his suit and shirt had been cleaned and pressed, so we didn't have those fibers to examine as we had President Kennedy's clothes to conduct an examination of the fibers, and it was quite an experience. My job was to watch Governor Conley watch himself being shot on the Zapruder film, and I sat and watched him observe it. And as you know, Governor Conley believes he was hit by a second bullet, not by the same bullet which hit the president. And it is not indispensable that the single bullet theory be present. You could account for the sequence if the first shot hit the president, the second shot hit the governor, and the third shot hit the president's head. But I think that is not the way it happened from all of the evidence. But I think it is a very healthy thing in our society to discuss the matter. People have a great curiosity about it, and this is quite a distinguished symposium on the 40th anniversary, and I'm pleased to be with you today. I'm not sure I'll be pleased after the panel discussion starts, but I'll be glad to respond to questions, and as I always say, when I speak that I'll be glad to answer questions, I'll be glad not to answer questions, but today I think I'll be answering questions. Thank you all very much.